मैं तेरे को पुट अप करके दिखाता हूँ इन 5 minutes की क्या चीज है बेसिकली द एप्लीकेशन.
We are live now.
Thank you, Abhinav. A very, very good evening to a very good evening, afternoon, and morning, in fact, from any part of the world that is joining us, to everyone who's joining us for this very, very interesting live session. As you all know, this live session is being carried out on the topic artificial intelligence and its interaction basically with intellectual property rights and ownership. There's been a lot of debate and discussion going on about this topic, especially in light of multiple litigations going on across jurisdictions on this issue. Now, we are very, very honored to have Mr. Ankit Sahni with us for today's live session. Sir is an extremely experienced intellectual property lawyer who has tons of experience both with intellectual property advisory as well as intellectual property litigation. As far as the field of AI and IP is concerned, sir has been doing some tremendous work. He has advised and assisted the Parliamentary Standing Committee on this particular issue, and his suggestions were in fact incorporated in the report as well. He is the creator of, in my opinion, what is India's first artificial intelligence creation app, in the sense that it's a painting app which creates, new things or new artworks or new works. So sir has been doing some tremendous work in this area, and for his efforts, he has also been recognized as one of the top 50 most influential people in IP by the leading IP publication managing IP. So sir, not with us today.
Thank you so much, Sharath. Many thanks again for your invitation to be back on your show live this time on the TCLF channel. Many thanks also to your technical team who've put in their efforts to have this organized. And as well, I'm very happy to be back on this forum. And I'm looking forward to this discussion and to any questions that anybody may have from the audience or from your team. I will try my best to answer those.
Thank you, sir. Now, beginning with the conversation, sir, let's go back to fundamentals of this. What is, in your opinion, an AI-generated invention, and why does the definition matter? In the sense that why is it important to arrive at a standardized definition for AI-generated inventions?
Great question. I think that pretty much sums up the starting point, even in my personal opinion, about how should we start looking at artificial intelligence in the context of intellectual property rights. And you would always begin by asking yourself the question, what is AI-generated content or AI-generated innovation or creativity or invention? Now, broadly, there are two kinds of content or innovations or inventions, etc., that we are seeing, both in the context of the Dabas test case, the application for the patent application that Mr. Taylor and others have filed, identifying the AI as the sole inventor. In that context, as well as in the context of what we are seeing, various mainstream applications, tools that are available, musicians, artists, writers, and everything, whether it's GPT-3 or it is, so many different tools that are now so accessible to all of us that this question becomes very relevant in that context. Now, broadly speaking, the applications are of two kinds. The first kind of applications are those that require some kind of human assistance or input to be able to come at an output, right? So we sometimes refer to them as assistive, AI assistive output. The other category is applications that don't need any or much input from a human being to generate the output, right? Perhaps aside from a prompt as regards a general theme or a direction in when output is expected, they more or less do what they do autonomously, as is apparently the case with the Davos application that has been filed claiming AI as the sole inventor, as if the AI is solely responsible for autonomously creating the invention, which has been applied for to seek protection under patent laws, right? So these are two broad categories. And why it becomes important to define what eventually would be recognized the law as AI generated in output or AI assistive or AI autonomously generated output is because how it is defined will naturally have impact on the consequent rights and recognition or protection that that particular invention or content or innovation, etc., artwork receives, right? So it's important to define it, keeping in mind the various permutations and combinations, and also keep in mind the fact that in applications such as Raghav, where human beings' input is required to a certain extent, human also contributes to the creativity, although the final output gets generated is substantively different from any inputs that the human being gives, right? But there is a contribution in terms of giving a general outline or a direction or a theme and specific content, which either the human being has created themselves, or in my case, in the case of the test applications they filed before the Indian Copyright Office and later on before the US Copyright Office and the Canadian IP Office, that has a photograph that I took using my regular phone camera as one of the inputs, and the other input being a very famous painting called Sahni, which was painted by again the very famous world-renowned painter Vincent Van Gogh, who passed away, I think, in the late 1800s, and therefore by all means, it would be safe to presume that the painting by itself falls in the public domain as far as copyright law is concerned, right? So we use that as the theme or the style for Raghav, and using the picture which it took as the content in the photograph and the painting which it took as a style input, it reimagined the photograph or expressed it in its own way of understanding how, if Van Gogh were alive, how would he paint that particular scenery or that picture, right? So that's the whole purpose. In these cases, there is a human element or human creativity or contribution which is involved. Therefore, this human-assisted AI-generated output could be treated differently because there will always be the requirement of recognizing the human input. Whereas on the other hand, where there is little or no human input required and AI is more or less autonomously generating content or inventions, etc., there, of course, a different treatment may be made by the lawmakers, because there the credit goes almost entirely to the AI app, and in a certain sense to the people who created the AI app, taught the AI app what it knows today, the level at which it has reached, the data set on which it has trained, and the manner in which it has been trained would be very relevant in determining how the eventual output looks like. These are the two broad kinds of works that I've come across. And I do believe under law, there should be appropriate identification of both AI-assisted, human-assisted AI works or outputs, as well as autonomously generated AI output.
Right, sir. That's a very interesting observation, sir. And I think as far as the inclusion under the law is concerned, what my personal opinion is that the definition should encompass both of these works, because essentially, even in the case wherein the human is putting an input into the artificial intelligence, which essentially creates the output, then there is the ultimate work then is created by the AI, even though there is human involvement. However, across the definition or standardized definition and encompassing both of these works comes across, then the law can, of course, choose to treat the two differently in terms of the grant of rights and the kind of protections that are provided under the law. But as you very rightly pointed out, there are these two kinds of works, and the definition, any standardized definition should observe both of these kind of works. So you've also talked about Raghav, sir, which is an artificial intelligence painting app, and you are the creator of that artificial intelligence app. So for like, can you tell us more about Raghav? First of all, what was the fundamental motivation behind launching and creating Raghav? And secondly, so in very theoretical terms, how does it work? Like, if you could explain it in a very basic sense.
Sure. So, first of all, I haven't developed Raghav. Raghav was developed uh, by a team that was by a person, a computer engineer, a graduate in computer and AI field, who was at that point in time studying at the Mila Institute in Montreal, which is an institute that apparently is renowned and is known widely for specializing in artificial intelligence. So Raghav, who was a master student there at that point in time, led the development team. We embarked on his journey in late 2019, and then it took us a few months to get the app in place, make it reach a level where we wanted it to perform certain functions the way we had imagined, and the way we wanted the output or the level of output or functionality that was essential for us to uh, prepare for our legal test cases, the ones that we filed at the Indian Copyright Office and in subsequent applications for other international copyright offices. So we needed to develop it, and that's how it got commissioned out of my funds I acquired. So it was a commission project, and I acquired ownership rights over Raghav in 2019. Once the application was handed over to me, of course, I still continue to enjoy the excellent assistance of the development team, particularly of Mr. Raghav Gupta, who developed this. And that time it didn't have a name. We were using a project name to refer to it internally in our emails and everything. So when it was being handed over, we all thought, what should we name it, right? And then we thought of the name Raghav, which is an abbreviation of Robust Artificially Intelligent Graphics and Arts Visualizer, which basically describes what it does. But it's also the first name of the person who led the development, Raghav Gupta. So we wanted to keep it after his name. And I thought, in this entire journey, it would be appropriate, because that's quite the irony. After the project team, particularly Mr. Gupta, assigned the rights of the application to me, under the present system of laws that we have, there would be absolutely no place where Mr. Gupta's name would find a place or would find a mention. And I thought, we are embarking on something, on testing a legal proposition, and it could not have been possible without the developers, right? The application as it stands today is a consequence of how the developers worked on it and what kind of data they trained it on. So I thought, look, I really feel, because your name is not going to come anywhere, we want to give you credit, and who knows what direction lawmakers take as far as this is concerned. This is absolutely new and uncharted territories that we embarked on, and even the Dabas team, they of course were the very first ones to do this, and a large part of the inspiration behind doing a copyright project, the credit behind that or the credit of that goes to Ryan Abbott, who's also appeared on your show, on your forum before, and who I really have a lot of respect for personally. So he's been a source of inspiration and guidance, and that's sort of why we thought now the patent thing is being done by the Dabas team. The same issue comes up in copyright. Of course, copyright law comes with its own set of challenges and issues because it's not exactly the considerations and other things are not exactly the same as in patent law. So we thought we should start this. But given how, like I said, given how things are in most parts of the world, the name of the developer at the moment of the app doesn't come anywhere. So we thought that, in fact, I personally insisted that we should call it Raghav, so that when this does reach anywhere, at that point in time, we had no expectation of this matter really reaching anywhere. And, making it big in media and news and everything. But when it eventually did, it got known by its name Raghav, and that way people started reaching out to the developer as well to take his quotation, ask him about what his perspectives are from the developers community. What do they think of applications or tools like these that they're developing, and if the output that these tools generate, if they're not rendered protection under law, would that have an impact on how incentivized they feel or how motivated they feel to code and create and develop something like this? So that was the motivation and the reason behind getting into this project.
Right, sir. And like you very rightly mentioned, the incentivization part, how would the creators or developers of this kind of technology, basically, how incentivized they should feel to further create these kind of technologies? That's a very important question, a policy question that I think lies before the authorities and agencies across the world with respect to this issue. And that exactly leads us to our next question, sir. Why do you think, why is it important, in a sense, to grant IP protection? Or let's put it down even more simply, that is the argument by many leading scholars around the world. Why is it important to recognize artificial intelligence as the, let's say, in the case of patents, or the creator in terms of copyrights for the works or the inventions that are created?
Right. No, very relevant again, and one of the most frequently encountered questions or issues or debates. Right. So there are two sets of views as I've come across, in this journey. One set of views is there are certain stakeholders, for reasons that are best known to them, they advocate for a legal regime where anything that is not created by a human being is rendered publici juris, or does not become subject matter of, or comes outside of protection granted by copyright laws or patent laws, etc., or even common law, under common law, etc. So they want that creations that technologies make, especially technologies that generate autonomous sort of content and things like that, those should come in the public domain completely. That's one view. The other view is that the one which I personally subscribe to, and the one that various others, including Professor Ryan Abbott and his team, from the submissions or the positions or the arguments that they've been making before different courts, before different regulators. That view is that, look, it's very important to protect output generated by artificial intelligence, regardless of whether it was generated autonomously, or it was independently, or it was generated with the assistance of a human being. You see, it's very simple. Now, if developers like Raghav Gupta create, and there are dozens of such developers, both big and small, they're large companies, there are startups, there are individual developers, everybody that is coming up with solutions, right? Like I mentioned, there's GPT-3, that scale of solutions that's helping a number of people who are in the publishing or the media industries to come up with articles, commentaries, content very quickly, right? Similarly, applications like Raghav that are helping people or that have the potential of helping people generate quality artwork, whatever it's worth, whether you'd like to put it up on a wall or you'd like to print it on t-shirts and sell it, make a business out of it, do whatever you like, but this is all original, very quality artistic work which is being rendered, right? Now all of these technologies, the fundamental purpose of using technology, why we use a mobile phone at all, or why we use a laptop or a camera or the internet or a smart watch or whatever. All of these things are being used by human beings to make their life easy. And that's basically why somebody would want to use artificial intelligence, because it makes one's lives easy. Artificial intelligence, machine learning, natural language processing, blah, 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 so on and so forth. All of these things are a consequence of the generations and generations of, upskilling, upgrading, and, sort of evolution of technology that has happened, right? And this is the next logical consequence or step that has come in our journey right from the 50s, 60s, or maybe the 70s, 80s, when the first commercial mobile phone came, right, to where we are at, the internet boom in the early 90s, and then broadband, and then, smartphones and smart devices and so on, to where we've reached now. Web 3.0, blockchain, artificial intelligence, metaverses, so on and so forth, right? All of these things. Now, if we were to suddenly say, look, we've come to a point in time where there's technology which is assisting human beings to generate content or create inventions, so on and so forth. All of these things are making human lives easy. If we were to not protect the output of these machines, what would happen is it would severely disincentivize the people who are creating these solutions. Now, let's say I'm a small startup and I spend some 2-3 years working on a solution which I take to the market as my company is offering. And that solution, what it does is, with some basic inputs from a human being, it's able to generate completely novel, unique, creative, original tunes, okay? Beats or tunes or, whatever, music essentially, right? So it can be used by musicians to generate new songs, for instance, by rappers who need a beat in the background, with somebody who's making a documentary or a vlog, they need background music, etc., right? So it can be used for all of these purposes. Now imagine if the output that gets generated by this application were to be treated by law or under law as publicity juris, why would somebody buy this application eventually? Of course, there would still be buyers of the application for a number of reasons, but by and large, if you see, it would have a severe impact on the commercial use of or the demand of this application, right? So in turn, the person that has generated this tool, so one model for that person to monetize his creation could be to allow people to subscribe to it, pay a monthly fee, log on using your browser, host it on the cloud, just log in, generate beats, download when you like something, when you've reached a point that you've created or the app has created something that you like, download and it's yours to keep, to on whatever, on perpetual license or whatever it is, right? Now, if this was to be made publicity juris, what would be the motivation or the incentive behind the startup that has invested possibly months and months or years and years of time in developing this, training this on a data set, right? And making it reach where it is. And it's a socially productive, socially beneficial solution, because imagine how easy it would make for so many bedroom artists and musicians to create quality music, right? Which otherwise, if they were to manually do using a tool that requires manual input, it would take them a lot of time to, maybe weeks, what they're able to generate in minutes using an application like that. If we don't protect the end products of AI applications and tools, we are disincentivizing people who create these, and therefore we are kind of severing or putting in a break in the value chain. That is important for lawmakers to be thoughtful about, basically to think about, to protect, right? So that's kind of the logic why artificial intelligence generated content should be protected. From a country's perspective, the second reason is, assuming Mr. Raghav Gupta and his other colleagues, incidentally, they're Indian citizens. Assuming they're all of them are Indian citizens, they're domiciled in India, staying in India. They use their technical qualification, their skills, their talent to create an application like Raghav, right? And Raghav, with its ability to generate unique artwork within seconds or minutes, based on what input you give it, starts creating artworks, right? And I start using those artworks on T-shirts or doormats, and I start a business out of that. It kicks off very well. People, the consuming public receives it very well, and they think this is some very interesting artwork that the AI is generating, very unique, very different from what they've seen, right? So imagine how many people are actually benefiting from the end sale of the article that does the artwork, right? Once an article such as a T-shirt or a mug or a doormat, etc., that bears the artwork generated by Raghav gets sold, it makes a customer happy. The customer pays to me, which is the company that's utilizing Raghav, let's say. I pay GST on that sale, the government earns GST from that, right? I in turn pay a certain license fee or royalty, or I pay a one-time fee to developers like Raghav to develop an application like this, right? Now, on the unique designs that Raghav or any other tool, similar tool generates, assuming if lawmakers were to treat this, all these outputs as publicity juris, I would only need to, in a country like India, I would only need to sell one T-shirt or two T-shirts, and the next day I will see the market flooded with T-shirts and God knows, coasters and mugs and everything bearing the same design, right? What would be my incentive to continue business like that, or to invest money in developing something like Raghav, or acquiring something like Raghav as a solution, right? Zilch. So that's the precise point. And from a country's perspective, coming back to that question, you see all of these economic activities, entire economic chain is placed within the boundaries of the Republic of India. Any sale that happens, any commercialization that happens on the shores, the country earns revenue off it. They earn GST off it. Any sales, whether in terms of out licensing of the AI as a solution, or in terms of me as a business putting these artworks on any articles, exporting them outside of India, that's foreign exchange coming into India. Till our laws are made to protect these creations, eventually it's a loss for the country, for the society, for the entire economic chip and the system, because we're the ones who are losing out by making works which were otherwise of same or similar quality, if not better, than what a talented artist, a human being would create, and just letting it be publicity juris. So if we don't protect intellectual property, we cannot commercialize it. If we cannot commercialize it, everybody stands to lose. So that is basically an outline of what my views are. But of course, there are always, like I said at the beginning, always people who subscribe to a different thought. And their arguments, as far as I've been able to understand over time, is that they say, look, intellectual property laws were created primarily to protect human creations. and to reward a human being for the talent or the skills that they possess, not technology. And therefore, anything that a technology autonomously generates should completely be excluded from the purview of protection granted by intellectual property rights. So that's their perspective. I respect their views, but I differ in my outlook and in my perspectives, as I shared with you before.
Right, sir. I think that's a very insightful perspective into the entire situation. Of course, sir, we'll talk about the Dabas litigations in the latter course of our conversation. But I think another reason which I can stumble upon and gather from your answer is also that when you grant this protection, or basically when you recognize the AI as the creator or as the inventor, you're also serving an information function. And that information function is a lot of importance, wherein the public gets to know who is the original creator or the inventor. Someone else might be the owner or the enforcer of the rights that lie in the technology, but that does not mean necessarily that the same person or human itself was the creator or the inventor. And I think that information purpose or that information function is also very important. Coming another point that flows across, or another question that flows across from all this, is the debate surrounding the rights, wherein there is a debate as to who gets the rights AI created or AI generated work, and who should enforce these rights. So, sir, what are your views on that?
I mean, this may seem a little oversimplified to a lot of people when they hear this, but the approach that I've followed consistently, whether it was before the committee, when I was addressing them on these very questions or similar questions that they had, and one must give full credit to our parliamentarians, because I was personally taken aback. It was an experience which was very different than any other experience. I've had one more opportunity of addressing another standing committee, which was on they were reviewing a very limited matter, which was the amendments to the Cinematograph Act. But that was separate. But this particular engagement with the standing committee, I was pleasantly surprised at the level of preparation that the parliamentarians who were present, both from the upper house, Rajya Sabha, as well as the lower house, Lok Sabha, and the kind of questions that they wanted to ask, it did appear that they were already very well aware of the challenges that these things would pose, and taking one or the other policy position at this stage where we are at would come with its necessary implications and impact on one set of stakeholders or the other. So they were very wary of this. But some of the examples that I took, and I would like to take the liberty of using them here as well. See, let's first of all look at legally what changes if I use an application to generate something. You see, back in 1994, following the UK copyright law was amended in the 80s. And the Indian law, much on the lines of the UK law, of course, very different from the UK Act, the UK Act that concerns copyright, patents, and trademarks. It underwent a lot of changes. The changes there were far more substantive than the ones that our amendments here in 1994 introduced. But the 1994 amendment brought in a very important change. 1994 would also mean that this was the time when we are talking about the early internet age, the early personal computer and internet age in India. So, back then we had just started to have PCs and Macs and, basic dial-up internet in homes. So it had become very important for lawmakers to consider with the boom in that space, in that industry, to make sufficient protection or at least facilitation of what would happen to computer generated content. Because before that, Even animations were hand drawn for the longest time ever. Large studios like Disney, etc., they would also draw entire, sequences of animations running into hours and hours, episodes and episodes of different cartoons that we're and characters that we've all grown up seeing, right? So those are also drawn and colored and animated by hand, at least partially or to a large extent. Now with the computer coming in, there were tools that came, whether something as simple as MS Paint, which was introduced by Windows and right from its very early versions, to more sophisticated applications that started to come. What would happen to works that are generated using computers, right? That question needed to be answered. So what they did, not the best of or the most substantive of amendments, unfortunately, but it is what it is. In 1994, they brought in an amendment which, amongst other things, amended the definition of author as it exists under the Indian Copyright Act, under Section 2D. And they changed the definition of author. I'm reading from it, the relevant parts. It says author means in relation to any literary, dramatic, musical, or artistic work which is computer generated, the person who causes the work to be created. So they brought the concept of, let's call it custodianship, that the person who uses the computer to cause the work to be created, right, in the case of a computer generated work, would be entitled to identify himself or herself as the author for the purposes of the act, which means expressly there is a provision, not from today, from 1994, that recognizes computer generated literary, dramatic, musical, or artistic works as copyrightable works, if you were to interpret this in this sense. And practically, of course, as an IP attorney, over the years, we've filed dozens and dozens of, possibly scores of applications for different things that have been generated by computers, whether it's graphics or it's music or it's cinematograph films, etc. Right? So this is the concept that they created. Now, in the context of AI, it's very simple. If you were to draw parallels between this concept or this jurisprudence that got created by way of this amendment, the person that is using or operating the AI app would by default become the person who causes the work to be generated. AI is obviously computer, right? So AI generated work will qualify as computer generated work. And the person that's operating that tool or that application, which eventually results in that particular work getting generated, will, under the present system at least, be entitled to call themselves the author of that work. So that's the answer to that question. And in terms of drawing a parallel, and the example that I gave before the standing committee as well, also before other forums, is that imagine it to be an apple tree in your garden. If it's an apple tree, it bears apples, at least once every season, for instance. Now the apple tree that grows in your garden belongs to you. Therefore, the apple that it generates, why taking the example of a tree is because you have little or no contribution to the texture of the apple or the shape of the apple or how many apples a particular tree is going to bear or how juicy or how sweet they'll be, right? You're giving direction to the tree as far as your talent or skill is concerned. If you're a talented or skilled apple farmer, you would know what nutrients to give to the tree, how to clear the area surrounding the tree and make sure there are no other plants that would prove to be counterproductive to the tree's ecosystem. What kind of trimming does the tree require? How does one treat any insects or any infections, etc., whatever, any pests, rodents, etc., that may attack the tree, or any infections, etc., or any insects, etc. That may. So what kind of insecticide should you put it? What stage should you put it, etc. All of this contributes in ensuring that the produce of the tree, the apple is juicier, crunchier, it's got a brighter color, it's got a better texture, etc. But let's remind ourselves, right? Way before human beings existed, right? There were always apple trees. There are still apple trees that grow in the wild. It doesn't mean that a human being is required for apple trees to grow and for apples to be produced, right? And you never know. There is every probability for an apple tree that is growing in the wild to grow apples that may be sweeter or crunchier than the apples that come from the farm of a very talented, very skilled farmer who's famous for generating quality produce, apple produce each year, right? So it's very similar to how AI operates, especially in the case of AI that works with a greater level of independence with lesser or negligible human input. We are still taking the pains to operate it and giving it necessary commands, etc., or input where it's required. But the same way, any apple tree that lies in my orchard, that stands in my orchard or in my garden, bears the fruits. The fruits would be owned by me the same way any AI generated app to which I have lawful access, not illegal access or access which would, for instance, if this was a licensed access, any access that would contravene the terms of the license under which I'm accessing that tool, right? Let's take the best case, which was what we prepared for the test cases that we filed with Raghav's assistance. Raghav's example is that I wanted to be the absolute owner of the Raghav app. I didn't want further questions in the first case to arise from the fact that, well, it is somebody else who owns the option. They're giving it to you under license, and therefore it becomes questionable as to while you're operating it, whether it was licensed, your use was within the four corners of the license that they gave you. And if it was, then what did the license say about any output that gets generated? I want to complicate it, right? We took the best example possible. We went on a presumption where I needed to be the legal owner of the applicant, and I became the legal owner of the application. Similar to how if I was to have an apple tree, plant an apple tree and grow it in my garden, I would be the absolute owner of that tree, right? And any fruit that the tree bears each year, I would be entitled to commercialize it. I would be entitled to sell it. I would be entitled to eat it. I would be entitled to make pies out of it, God knows what, whatever I want. So it's not so complex as some people put it, unfortunately, because I've received a variety of comments, feedback, all of which I completely appreciate, but we're all learning. There's no one straight answer or one right approach to this thing. But in the midst of this learning that all of us do, comments, feedbacks, critique, they need to have, all of these things need to have a certain degree of reasonableness. Now, for somebody to say, I don't believe in AI, I don't believe in AI-related output, or the fact that AI is really anything at all, or can make something that deserves to be protected, etc., till an AI takes a human or humanoid form, walks up to a table, addressing a conference and is able to speak. Those kind of, apologies for putting it this way, but those kind of ridiculous examples don't make sense. They don't help either the cause or the debate or the questions that need to be asked at this stage. This is not about giving rise to AI. This is not about personification of AI. That is a separate debate which is unconnected to, or at least as of now, appears to be unconnected to the debate that we're having around protection of AI rights. This has got nothing to do with AI taking a humanoid form, AI walking with us, AI taking care of my kids, AI doing my chores and things like that. We are not in this discussion talking about what rights AI should get. We are only talking about what treatment should AI generated content or inventions be given, right? Because if the human being is operating the AI is not talented or skilled to be able to generate that invention, why should that human being be entitled to get himself the recognition of being the author or the creator of something? He can be the economic owner. There is no problem. If I bear, if the apple tree grows in my garden, I am in every sense the economic owner of the apples that fall from that tree, right? And I can sell them in the market, and I can get compensated. I can commercialize my apple harvest, right? But I don't, and I cannot be entitled to tell the world at large that, you know what, I created this apple with my own hands. This is a human creation, because it's not, because I do not possess the talent or the skills or the ability to produce what has been produced, right? So we should keep these debates very separate from each other. The other question that I frequently receive or I've talked about is infringement. How will the AI commit infringement? The question is not about AI again being personified, and therefore AI is like a trust or like a legal entity by itself, operating like a company, and God knows what kind of views I've had the pleasure of reading. But it's not about that. It's not about the AI having a bank account or having a company, and then when the products of its creation are monetized, they should come back to the AI, and the human should only operate as a trustee to that legal entity, whatever nature, whatever shape that legal entity takes in the eyes of law. And if tomorrow somebody was to sue the AI for infringement, then and then a court was to award damages, then money should be deducted from the AI's bank account. No, this has got nothing to do with this ridiculous stuff. And these are actual views, Shashwat, that I've received from people who've connected with me over email, who've reached out to me on telephone or otherwise for a chat, or have addressed these issues without even talking to me in a face-to-face conversation or at a public forum like this. But I've gone ahead and written. Of course, they have every right to address this, but in my personal view, I don't think this is quite the thing. Infringement, the same thing, the same concept. Now, infringement, let's drop a parallel between infringement and the quality of apples that come out. Now, if the quality of apples that come out are such that, let's say some of the apples are rotten from inside, or they're infested by some kind of insects on the, or worms on the inside. Now I take the decision, I look at the tree is incapable of deciding, right, of whether the apples need to be taken to the farmer's market to be sold or not. I, as the owner of the tree or the owner of the land on which tree is, planted, and on which it has produced this output, the apples, I, as the owner, enjoy the ultimate prerogative, the discretion to decide whether these look good enough for me to take them to the market and sell them. And consequently, when I have that sole prerogative or that discretion to decide what should I do with the apples, should I throw them out, should I consume them myself, or should I take them to the market and sell them to some third person, right? If they turn out to be rotten, whose liability would it be? It's not going to be the tree's liability, right? It's going to be my liability, because in law, I exercise the ultimate call or the discretion or the choice of saying, okay, these appear to be good, marketable apples, and if I call them apples and sell them as apples, I think people are going to enjoy them, and nobody's going to come back to me with a consumer claim or something saying, I felt sick, or this isn't apple at all, or it wasn't sweet, or what you've given to me is an apple which is rotten on the inside, or whatever, right? And if somebody actually does, I will be personally liable, because I am the economic owner of the apples, and I exercise the discretion of deciding whether these should be sold to a third person or not. Similarly, when Raghav, for instance, generates a piece of art, it is my obligation to check if that particular artwork infringes somebody's rights or not. How difficult is that, or how different is that from what we already do? I doodle at the back of my notebook, or even if I am a professional painter, I paint something and I create something. If it ends up infringing somebody's rights, right, who would be liable? I would be liable. Before I take the painting to the market and sell it and commercialize it, or license it to somebody else and allow them to place the image, the picture on t-shirts or on mugs or whatever it is, commercialize it, that sense, merchandising. right? I need to be cautious, or I need to exercise diligence to be able to assure myself that this is not infringing any third party's work. Similarly, the AI job ends once it produces what it intends to produce. Taking it to the market, applying for copyright, commercializing it, monetizing it, printing it on t-shirts and selling those t-shirts, whether or not that particular artistic work infringes somebody else's rights, eventually that call also is mine. That discretion or that prerogative also resides in me. And when I take that call, the prerogative comes with the obligation or the consequent duty of suffering or being liable for any consequences that arise as a result of me exercising that choice. So I don't think it's so complex, at least at this stage where we are at. Some people are projecting it to be, this debate and this question, what you talked about.
Thank you, sir. That was a very, very detailed insight into the entire question. And I completely agree that it's like connecting two unconnected notions, wherein personhood of AI is a completely different question, and which should be kept aside from how the rights would be enforced, because essentially we're again talking about humans as owners and AI as inventors. So you very rightly explained that. Now, coming back to the last segment of this conversation, sir, I have a two-part question. First, what essentially were the views of the standing committee? What were their observations with respect to this issue? If you could just briefly summarize, and also then talk about the very last part, wherein if you could tell us from the Dabas litigation, what is the view of other jurisdictions in this area? If you could summarize 2 to 3 jurisdictions.
Sure. So on the first question, Shashwat, because we're all bound by parliamentary privilege, I can't really exactly tell what their views were, other than what is expressed by the standing committee in the report. The report is what was made public. So I will stick to what was said by the committee in the report. Now, a lot of people have criticized the standing committee on taking out that report, at least certain sections have been written in a particular way, which either was not as descriptive or as detailed as it should have been, or because of such lack of detail, ended up asking more questions or creating more doubts, etc., than having any. I think, from my perspective, I absolutely commend the effort that has gone into creating quite an exhaustive report, especially in the context of the magnanimity of issues or subject matters that the standing committee was dealing with. Now, they convened for the first time, to my knowledge, in November 2020 or December 2020 to review the intellectual property regime in India. From November 2020 to finally publishing your report, which runs into several pages, excess of, I think, some 100, 200 or what, 300 pages, right? Which they published as early as soon as July 2021, within some 7 or 8 months of having convened for the first time to talk about this, review this, receive views from various stakeholders, trade bodies, from lawyers like myself, from universities, from various departments, different ministries, and then come at the conclusion, right? And even from various stakeholders who could not be in person at Sansad Bhavan, but who wrote to the standing committee, even their views have been considered, acknowledged, and taken into account. So, what has come out broadly, because they were reviewing so many different subjects. They were reviewing GI, they were reviewing patents, they were reviewing trademark, copyright, they were reviewing the overall infrastructural position at the IP office. What kind of salaries are being paid, how incentivized or rewarded do the IP office employees feel? What are the other challenges that the country has, culturally or from the perspective of being a society faces? How to increase innovation or reward innovation done at the grassroots level. All of these things to do or to be able to complete in a matter of 7-8 months, in time for it to be tabled ahead of the monsoon session of the parliament, that was commendable, right? And having worked for some amount of time in because there was a lot of back and forth aside from my physical submissions which I made in person before the standing committee. There were a lot of things that were submitted. There were questions raised by the parliamentarians or by the officers who were the secretaries, etc. There, part of the committee, addressing those questions. A lot of correspondence that was going on. So full credit to the team that could ensure that this report comes out. Now, on the limited point of artificial intelligence, what they make is, there are a lot of things that they could not talk about for n number of reasons, but we are at least not here to criticize the lack of detail in that report. I'm here to point out and commend them on the couple of boxes that the report ticks, which is highlighting the fact that, look, these are at least two laws that you would need to amend, the Patents Act and the Copyright Act, from the perspective of ensuring that AI-generated contents or AI-created inventions are suitably recognized. So that was their main, or the crux of the main recommendation in this context. They seem to have agreed with the submissions that I and other stakeholders made, highlighting to them also various industry reports that we cited, which have been quoted in the standing committee's report as well, which talk about the level of contribution that AI-generated innovation is going to add to the Indian economy. It's a one-of-a-kind report made by Accenture, which they've relied upon. So all these things need to be seen from that level, a 5,000 feet view, and not always by everybody from such a microscopic level. Of course, we should come to these levels when the time comes, but this is broadly what they talked about, and they did recommend the government to look into how these laws can be amended to suitably provide for protection to AI-created inventions as well as AI-generated content. So that's what the report talks about broadly. Sorry, what was your second question, Shashwat, if you could repeat that?
In light of the Davos litigation, how have the other jurisdictions dealt with this question? If you could summarize their positions.
Sure. So see, there have been mixed reactions. There have been jurisdictions that have outrightly said, look, today as the law stands, we are unable to entertain the prospects of having a non-human inventor, or in our case, a non-human author, right? There have been jurisdictions such as South Africa that went ahead with publishing what was possibly the world's first patent application published, which highlighted or identified a non-human, an AI, as the inventor, sole inventor of an invention, right? The reasons were different because the country has a different regime, has different procedure. South Africa, before publishing, they don't do substantive examination. So that was partially why that application went ahead. But other jurisdictions such as Australia came out with bravely. Again, full credit to the outlook or the approach that the Australian higher judiciary took. The bench that was hearing this particular appeal, how they recognized or how they creatively interpreted, or in technical terms gave a purposive interpretation, to the provisions, while recognizing the fact when the amendments were made, they were certainly not made with the view that tomorrow there will be artificial intelligence and there will be a time when the computer or technology by itself, without any inputs from the human being, be able to create an invention by itself, right? While recognizing that, utilizing the legislative framework that they were working with, interpreting it in a forwarding way to facilitate the recognition of AI as an inventor, and to prodding, pushing, and telling the IP office to consider this again in light of what they said. I think that judgment falls on the other side of the spectrum, the most promising as far as this development is concerned, and as far as the story of giving recognition to AI generated inventions or content is concerned. We were fortunate for the Corporate Office in India to consider this. They took a brave interpretation of what we submitted at that point in time. Eventually, there was a very interesting development that happened. In December last year, 2021, I received a withdrawal notice. I was contacted by representatives from the IP office and from the government that very cordially explained to me that, look, we are mindful of the recommendations that the standing committee has made. We are also aware of the fact that you've submitted this application, the registration certificate, and you've addressed these issues and talked about the Raghav project in detail with the standing committee. But we face a very catch-22 like situation, because on one hand, the standing committee recommends and says that, look, you need to amend your laws to allow for AI generated content to be copyrighted, or AI generated inventions to be rendered protection as a patent. But on the other hand, when we go ahead and grant you copyright registration and identified Raghav artificial intelligence painting app as a co-author alongside you, we sort of, or that registration led to a dichotomous situation where it could be interpreted to mean that the existing laws are sufficient, which is why a registration could be granted. So only because of this catch-22 which is created, and the fact that we would like to bring grounds for the amendments to be brought in now, we are going to issue you a withdrawal notice, and you would obviously be at liberty to challenge that or take it to court in appeal or whatever remedies you're entitled to under law. So that in the meantime, if a court were to take, give you indulgence and take a view on the issue on how this is to be interpreted, that would also be helpful to the lawmakers. So that's where we are at. I received the withdrawal notice in December. My team and I, we prepared a substantive response to it, which has been sent to the Copyright Office and other stakeholders involved. And now we are awaiting a hearing in the matter, if at all we get one, or the decision of the Copyright Office to refuse the application or to accept our submissions and continue with it, or whatever it is. So that's where that position is. To take this journey forward, how we had planned it or staggered it was, once we were to receive some success at the Indian, or success or not, to be honest, we were not expecting that the Copyright Office would eventually agree to register this. Right, and be seen as taking a very forward-looking step in that sense. But we obviously expected that the Copyright Office would, at the outset, refuse all of the three applications, the three different permutations that we filed for artwork that Raghav generated. But because we succeeded, we had planned, the moment we receive an order from one Copyright Office, the Indian Copyright Office, we will apply to other copyright offices across the world. Not every country has a regime or follows a system where you can apply for copyright and they examine it and then they give you registration. Many countries like the UK, etc., follow a system where there's a copyright law, but it just gives you automatic recognition over whatever you're entitled to claim copyright about or over. So that's because of that unique challenge, which is very different to the patent system. Almost every country, in fact, has a system where you apply for your invention and seek protection as a patent, etc., which is not the case with copyright. So our target jurisdictions, the set of target jurisdictions got limited. But in the first phase, we wanted to, after India, gauge the reactions of the US PTO. In this case, not the US PTO, but the US Copyright Office, because the US courts, by and large, and the US PTO by its has been very vocal about this. They've received in a number of different situations, not particularly AI, but a number of different situations. They've had the chance to examine ownership of intellectual property by non-human beings, or authorship of intellectual property of copyright by non-human beings, such as the case of that monkey clicking a selfie, so on and so forth. And they have had a very clear view about these things. They say, look, broadly, if it's not a human being, we cannot grant registration or protection to what you're seeking for over, right? So it'll be interesting to see their views. It's been a few months. I haven't received any response from them yet, but what I understand from the dashboard is that the application is under review. And once we get some kind of substantive examination, some kind of office action report, I will be happy to report that back to you and your team. On the Canadian side, again, another legal system that you to apply for registration of a copyright. So we applied before the Canadian IP office for protection of the same, similar kind of set, artwork generated by Raghav, and identifying Raghav and myself as authors for the artwork that got generated. So this is where we are at, but I'm eagerly looking forward to how these offices react, and to the other jurisdictions that we have in the pipeline where we intend to apply for protection over the course of time.
Absolutely, sir. We are looking forward to as well to all these developments, and we'll be very happy to receive further information on this so that we can take these sessions forward and in fact have a rather engaging discussion upon this, because in my opinion, sufficient debate and discussion and relevant debate and discussion on this topic would essentially lead to better outcomes for all stakeholders, be it the legislature, the executive, or the lawyers and the creators that are trying to get the recognition for this. So, sir, once again, this was an absolutely delightful and insightful conversation. So thank you so much, sir, for joining us today. And it's an honor every time we host you, sir.
Thank you so much, Shashwat, once again to you and your team for inviting me. It's always a pleasure to come on TCLF and engage with you on these very exciting debates and discussions that we keep having. So best of luck to you and your team for all future, engagements and engagements and events that you all keep organizing. Best of luck, and I look forward to speaking with you again.